We have one bill hearing today, and hopefully 6 bills we intend to work today, if my math's any good. Um, for everyone, my hope is, and obviously I try to be as flexible as possible. We'll keep this bill hearing to about an hour, and so my goal is that for the conferees that you limit your testimony to about 3 minutes, and not I'm not going to be super cut you off, but Trevor, for everyone, Trevor's interning for me this year, and Trevor volunteered, and I asked. He's got some signs to let you know when you have a minute and when we'd like you to wrap up. So he'll hold those up. He's a little closer to you than the vice chair is. You can barely see the vice chair up here, and so Trevor. And we will hold questions for each group. So we'll do proponents and then do questions, neutral, then questions, opponents, and then questions. So let's get started. I'm going to open the hearing on House Bill 2246, and we will have not Natalie, Jesse. Not used to saying that. Jesse, give us an overview.
Thank you, Mr. Chair. Good afternoon, committee. I am Jesse with the Revisor's Office, most officially known as Not Natalie. Unfortunately, Natalie has asked me to help her out because I'm the former Children and Seniors Revisor. And so this was an issue that children and seniors dealt with, and we've seen a few renditions of it. So I'm going to brief you on House Bill 2246. House Bill 2246 proposes a process to involuntarily transfer or discharge a resident from an adult care facility and a process to appeal that transfer or discharge. Most importantly, the bill defines adult care facility. So throughout the bill, you are limited to exactly that definition rather than the myriad of definitions regarding adult care home, nursing facility, etc. And so that's important to note. The bill proposes that the administrator of an adult residential care facility shall not involuntarily transfer or discharge a resident unless it's necessary for the resident's welfare and the resident's needs cannot be met by the facility, the health and safety of others is endangered, the resident has failed to pay, or the facility itself ceases to operate. So the administrator shall provide a written notice for that transfer or discharge at least 30 days before that transfer or discharge occurs, unless that resident is a danger to others or has an urgent medical need that needs attended to. The administrator is required to develop a discharge plan before a discharge occurs. If a resident receives a notice in violation of Section 1 of that process, the resident or the representative may appeal the involuntary transfer or discharge to the secretary, but they file that appeal with the Office of Administrative Hearings. A hearing will be held within 30 days after receiving the notice of the appeal. And when a resident files an appeal, the resident shall remain or be permitted to return and resume residence at that facility while that appeal is pending. So Section 2, we go into what is required on those forms that we're talking about. Section 2 requires the Secretary of Aging and Disability Services to make available a 30-day involuntary transfer or discharge notice form. So that's going to be the form that notices the resident that they're going to be transferred or discharged. The facilities are not required to use that form, but then the next subsection states information that is going to be required in that form, whether it's from the secretary or the facility uses its own. And some of those items include the reason for the transfer or discharge, evidence supporting that reason, names and contact information of parties involved, the effective date of that transfer or discharge, information about appealing, and a copy of the notice of appeal form. So the notice of appeal form shall include information such as contact and name information of the resident, in the person appealing this discharge. It shall state the facility, the date of the notice of the transfer discharge, and whether or not that person appealing would like an informal conference. Section 3 requires that an administrator, before issuing this notice of the transfer or discharge, that they must notify the resident of the transfer or discharge. They have to hold a meeting to discuss and attempt to resolve the transfer or discharge. They have to tell the resident that they can bring others to join the meeting and record the reason in the resident's clinical record. Section 4 requires the administrator to deliver the notice of the transfer or discharge to the person in person, as well as if the resident has one, a representative, the state long-term care ombudsman, and also place that in the resident's record. So Section 5 allows for an administrative hearing when a resident receives this notice of transfer or discharge, especially when the facility is not having its license revoked and is not renewed by the secretary. The resident or the representative of the resident may appeal the transfer or discharge by filing that notice of appeal form with administrative hearings within 15 days on the notice. If a resident is incapacitated or has no representative, the long-term care ombudsman may file an appeal for the resident. And within 15 days of the receipt of the notice of the appeal, the office shall hold a hearing. And within 10 days of that hearing, the office shall issue a decision. So Section 6 outlines the process for that informal hearing. So back in the notice of the transfer or discharge, that's also information that is to be provided to the resident. So the process for an informal hearing or conference, it has to be requested by the resident, and the purpose is to resolve the transfer or discharge. The conference can be held. The conference shall be held after the notice of appeal is filed, but before the hearing is held by the Office of Administrative Hearings. And if there's a resolution that comes out of that informal conference, then there will be no administrative hearing. Section 7 requires that an administrator provide a notice. So this is a different notice. Section 7 requires an administrator provide a notice of emergency transfer or discharge. And that notice has to be given either 48 hours before the transfer or 48 hours after the transfer or discharge. So the secretary is given authority in the bill to decide the criteria for what is an emergency. And if the transfer or discharge by the facility is considered an emergency under that criteria, the next sections 8, 9, and 10 will apply for these types of notices. So Section 8 requires that the secretary make available a form for the emergency transfer or discharge notices. So similar to the other one, the secretary is required to make a form. The facility does not have to use it, but there is certain information that must be included. And so it must include a statement of the right to appeal, the procedure to appeal, and a copy of the appeal notice form. The requirements for the appeal notice form for these emergency transfer or discharges is it includes the name of the resident, the person appealing, the reason for the transfer or discharge, the date of discharge, and a few other items. Section 9 requires that before an emergency transfer or discharge notice is provided, it also needs to be reviewed by the secretary, mainly to determine whether or not it meets the criteria of emergency as determined by the secretary. And so a resident it does have a provision that allows that the resident may be removed if truly needed. And then lastly, Section 10 grants residents the right to appeal an emergency or transfer discharge, similar to the 30-day. The resident or resident's representative may appeal within 7 days of receiving the notice. And then within 14 days of the receipt of the appeal notice, the Office of Administrative Hearings will have a hearing, and then the office shall issue a decision within 5 days of holding that hearing.
Committee questions for Natalie. Representative Heiberger. She didn't even hear me.
Thank you, Mr. Chair. Stole my line.
First,
are any of these facilities covered by the statute currently subject to any notice of appeal requirements under state or federal law?
Yes. So, Representative, currently, so let me take a moment. So in this bill, what you have is Section 1. If you take A all the way through D, that is current regulation under Secretary of Aging and Disability Services, and adult care homes are subject to that part. The new part is going to be the appeal process. And adult care home, let me double check. Does include nursing facility, so that's also included. But in federal law, nursing facilities already have that regulation as well as an appeal process. So they are subject under, adult care homes are subject under KDAD's regulation without the appeal part. And then nursing homes are also subject to the regulation, the federal law, and they get the appeal part. Does that help answer what
yes,
currently?
Yes, that's why I didn't see statute numbers, because this is all from regulation.
Correct. Yes. And the regulation number is actually going to be 2639-102.
Representative Titus.
Thank you, Mr. Chairman. Thank you, Ms. Pringle. Just to confirm, this bill was based primarily on recommendations from a judicial council review of the previous version. Is that right?
That is correct, and I can go into any further history if wanted.
Of course, I just wanted to make sure. Thank you.
Representative Smith.
Thank you, Mr. Chair. I've gone through this as much as I can. There is no provision for penalties if any of this is not followed, is there? So it's just going to become a matter of hearings and appeals and whoops, we should have done it different, and now we'll do it different now.
So, Representative, I will state that the only language in the bill that relates to any violation or penalty is that if the notice is provided in violation of the requirements, then there is a right to appeal, and that's the only provision related to that.
Representative Kincaid.
Thank you, Mr. Chair. Well, I thought that my question was going to be asked, but could you go ahead and go through the history of where we've been with this bill?
Sure. Thank you. Representative, yes. So this concept of taking the regulation and putting it into statute and then including the appeals process was introduced in House Bill 2004, and that was in early 2021 by Representative Highland. That bill was referred to Children and Seniors. In 2022, the Children and Seniors Committee passed it out of committee. It was not up for debate on the floor and died on the calendar as such. And then the chair, I believe, requested a judicial council review, which came out in December, in which the contents of this bill is based on.
Representative Vaughn. Vaughn, sorry.
That's me. Thank you, Mr. Chair. Thank you so much. I was trying to remember back to Children and Seniors, and if I remember correctly, I think one of the concerns was that during the appeal process, if there was a concern about the residents' danger to themselves or others, that wouldn't necessarily be addressed during that 30-day process. So I was wondering, were any provisions put in place to mitigate those concerns in the short term?
Yes. So Representative Vaughn, in the first part, when it talks about the 30-day notice, they still allow the resident to resume and or remain at the facility. When you talk about the emergency transfer notice, in that aspect, there is a provision that says the resident may be removed if they are a danger or if it's totally needed.
Representative Carmichael.
Thank you, Mr. Chair. Following up on Representative Heiberger's question regarding what remedies, if any, are available under federal law, I understand that most skilled nursing units have Medicare patients, if not Medicaid, and hence CMS, and those regulations apply. I'm not certain, however, what, if any, federal regulations apply to assisted care.
Yes, Representative Carmichael, there are no federal regulations when it comes to like adult care homes when you're talking about like assisted living situations. So the regulations only relate to nursing facilities.
And I thought this bill was focusing in large part on assisted care facilities, discharge from assisted care. So I'm trying to figure out what, if any, federal remedies are presently available in the event the wonderful place where my mother lives decides to boot her out, or to, as patients often think, transfer to memory care. What federal remedy? That we know we don't have a state procedure. That's what we're here about. But is there any federal recourse because they're not CMS?
Yes, Representative Carmichael, if your mother's in an assisted living, there's not any federal regulation in regards to that transfer or discharge, or to be able to appeal that.
And that's what this bill's about, isn't it?
Correct.
So there is a gap for assisted care patients, and we're going to close that with a state law because there's not a federal remedy at this point. Is that right?
If you choose to do so.
Well, certainly I'm going to choose to do so. Thank you.
Any other questions, committee? Okay, thank you, Jesse. Proponents, first on my list is Jamie Gideon.
Thank you, Chair Patton and members of the House Judiciary Committee for allowing me to testify in favor of HB 2246, creating the right to appeal an involuntary discharge or transfer from an adult residential care facility. The Alzheimer's Association is a leading voluntary health organization in Alzheimer's care, support, and research. Our mission is to eliminate Alzheimer's disease throughout the advancement of research, to provide enhanced care and support for all those who are affected, and to reduce the risk of dementia through the promotion of brain health. In Kansas, we have 2 chapters, which together serve all 105 counties. Persons with dementia are particularly affected by involuntary discharge because they can sometimes display common dementia behavioral symptoms, and because of that, be displaced from their home. They are also vulnerable to transfer trauma, which can lead to a decline in their physical and emotional well-being that can lead to significant health complications and even premature death. It can also trigger depression, psychological distress, and withdrawal from social activities. I ask that you support this bill because it will enhance the quality of care in residential settings and protect persons with dementia. Thank you. I will take the questions at the appropriate time.
Great, thank you. Next, because the people to the left of me are telling me Rachel should have gone first. So Rachel Imthern. Sorry about that. Little voices over here are like, you called on the wrong person. So sorry about that.
Thank you, Mr. Chair and committee. I stand in support of this long overdue bill. My husband, Charlie, was illegally evicted from an assisted living facility in 2011. That move cost him his life. He died 9 days later. Charlie was a busy, hardworking farmer rancher who developed Alzheimer's. And in time, I needed help with his care. I found a lovely brand new facility that offered a special memory care unit just for Alzheimer's residents. They guaranteed full care from early stage Alzheimer's to end of life. That was critical because, as Jamie told you, Alzheimer's patients can suffer from transfer trauma when they're moved, and it can be fatal, which it was for Charlie. Discharge regulations required a specific cause. There was a list of legitimate causes for discharge. It required a doctor's authorization and the 30-day written notice, except in emergencies, and there's provision for that. But here's what happened. This new facility was filling with residents. So the director asked the owners for more nurses. That's a regulation, sufficient staff. The owners said no, they turned him down. Instead of hiring staff, they fired nurses to cut the payroll and got rid of 6 residents that needed nursing care, Charlie and 5 other Alzheimer's residents. They falsified the records of these 6 gentlemen and totally misrepresented their care level and behavior and blamed them for their discharge. There was no cause. No doctors were notified. No advance notice. This all happened in one day. They broke our contracts, violated regulations, put human life at risk to increase profits, and they got by with it. The facility was never held accountable. KDADS, Aging Disability Services, they're the ones that write the regulations. They investigated and did nothing. Assisted living owners know that regulations are not enforced. By law, they have to be, but they're not. And the owners also know that the resident has not one thing they can do about it, nothing. They have no recourse. Nursing home residents can file an appeal under federal law, but assisted living residents have no legal rights. There's absolutely nothing they can do. So, unwarranted eviction remains the primary complaint received by the long-term care ombudsman year after year after year. House Bill 2246 gives assisted living residents the legal rights, the legal protection they have never had. I urge your support of this bill. Thank you.
Thank you. Dan Goodman. Unless someone to my left says I should ask someone else. Are we good? Okay, Dan, come on up.
Good afternoon, members of the committee. I My name is Dan Goodman. I'm the Executive Director for Kansas Advocates for Better Care. We are a statewide non-for-profit organization whose mission is to improve quality care for for folks in long-term care, regardless, or getting long-term care regardless of where they live. Thank you for the opportunity to appear before you regarding the need to close a gap in this due process, in the due process laws for Kansas, specifically the gap that exists in residents assisted living. I'm here today to ask for your support for HB 2246. Currently, there are no provisions for an independent third-party entity to review an eviction, even though Kansas regulations for all adult care homes are otherwise the same. State regulations give residents 30 days to find a safe, appropriate place to live and requires facility to provide the family with the reasons for discharge and doctor's approval. HB 2246 reflects the Judicial Council's recommendations, which provide a strong framework for an appeals process that balances residents' rights to due process and the health and safety of the residents' facility staff. You've now heard Rachel Imthern's story, and I think what's important to remember here is Rachel's story, although powerful, you need to know that Rachel and Charlie are not alone, and there have been many Kansans over a period of time that have been through the the involuntary eviction process and hence have suffered similar results. And so I would thank you again for giving me the opportunity to speak as a proponent to this bill. And I would urge you to close this gap and pass 2246 out of committee. Thank you.
Thank you. Camille Russell.
Good afternoon. Thank you, Chair. Thank you, committee, for allowing me to come and speak to you as a proponent for House Bill 2246. I am the state long-term care ombudsman, so will be the recipient, if you pass this bill, of a little bit more work in our office. And I can tell you that we believe it's very important to do. We believe that if we do this work, that it actually, in the long run, will create less work for everyone out there. So both federal and state regulations, as we've talked about already, do already have this process in place whereby they are supposed to do a 30-day involuntary discharge notice. It has specific information that's supposed to be on it. It has specific criteria. We are asking for nothing new from these adult care homes than they're already supposed to be doing in that regard, other than when they serve that notice to the person and their representative, they also would need to load that little form up on an email and send it to the state ombudsman's office. So that's the extra burden from what they're already supposed to be doing that we're asking for in this. It's important for us to know that there are a lot of homes that rightly and rarely will do an involuntary discharge notice. There are also homes that are serial offenders for many reasons that don't require, they don't supply the written notice at all. They often do not have an appropriate reason or rationale. And at the long-term care ombudsman's office, we do assist with about a third of the cases we did last year, even though we didn't get a written notice, that we came to know about this through usually a very frantic call from a family member or resident, that about a third of our cases involve these types of settings. And while we are somewhat successful in going through those notices and pointing out that they are insufficient in they're not doing the notices correctly and that they are not able to produce the evidence for their reasons for discharge. So we are somewhat successful when we find out about those, about having those rescinded and then working with the facility to come up with a real plan to serve that resident appropriately. A lot of these are from entities out there that we allow in Kansas to say they are a memory care provider. All they really have to do to say they're a memory care provider is put it on their website and the brochures, tell the people that they provide memory care, and our provision is that they will train their staff. We have no criteria for that training. That's another day. But a lot of these individuals that are really are subjective to this trauma. And I can tell you that we try and do follow-up for individuals that do get moved involuntarily. And we do often find individuals that live just a few days or weeks after they have moved. If you can imagine yourself the trauma that would exist if today, with the means that you have, you had something put in front of you that said, you can't live where you're living 30 days from now. And so I thank you very much. I appreciate the opportunity to be here today. I would ask that you please review my written testimony in that we do have an amendment. We think this would be stronger. I'd be happy to ask questions about that. And I thank you again today. We just really are asking these businesses to follow the rules that they've already agreed to. So thank you for being able to testify today.
Thank you. Linda Morse.
Good afternoon, Chair Patton and the members of this committee. I found Mrs. M. Thurn's testimony very compelling, and I could envision that a family member of mine could be in just such a position. And the reaction our family would have to make would be sudden. And even though we're paying $10,000 a month or whatever, I'll go on with my real testimony, but I just wanted to say that. Thank you for this opportunity to provide testimony in support of House Bill 2246, also known as Charlie's Bill. I'm Linda Morse, and I'm chair of the board of directors of the North Central Flint Hills Area Agency on Aging. And if you think from Maple Hill west to Beloit and north of Interstate, those are the 18 counties affected. Our nonprofit organization serves more than 60,000 older Kansans and people living with disabilities in that 18 county area. Under the Older Americans Act, our agency is charged to advocate and promote policies and legislation that help older Kansans live with independence and dignity in their homes and communities and support the well-being of the caregivers. We coordinate a complex delivery system of community-based services and serve hundreds of older adults and caregivers in that region. Our whole person approach with customers addresses social determinants of health. We provide timely supports and services to safeguard the welfare of Kansans we serve. We support House Bill 2246. We believe it improves processes and eliminates difficulties for Kansans seeking access to care. The 1987 Nursing Home Reform Act, as updated, allows residents of nursing facilities to appeal an involuntary eviction. However, as we've heard, residents of assisted living facilities, residential care facilities, and Homes Plus do not have recourse to appeal involuntary decisions. Currently, an eviction from an assisted living facility is a final decision under the Kansas Administrative Regulations, KAR 2639-102. House Bill 2246 will correct this serious lack of protection for assisted living facility residents to be upheld by licensing requirements by the state of Kansas. It will provide a guarantee of due process for assisted living residents and their caregivers. House Bill 2246 provides adequate protections to safeguard vulnerable adults from a wrongful discharge or transfer. We urge the committee to provide protection to Kansas residents of assisted living facilities. The same protections that nursing home facility residents and renters leasing private homes or apartments already enjoy. Please pass Charlie's Bill, House Bill 2246. I'm glad to meet Mrs. M. Thurn. Thank you very much for listening, and I hope that you understand the gravity of this issue. Thank you.
Thank you. Next, I have Glenda Du Bois.
Good afternoon, Chairman Patton and members of the committee. I am Glenda Du Bois, and I am the State Director of AARP Kansas. And I thank you for the opportunity to stand today to speak in support of House Bill 2246. AARP Kansas supports House Bill 2246, which provides the discharge of and protection rights to appeal involuntary discharge to residents in all Kansas adult residential facilities here in Kansas. This legislation, as AARP sees it, is critical for both Kansas residents and their caregivers, as it would make a very positive impact on the quality of life and quality of care for both. There are few things about this bill that AARP really sees as positive, and those are the ones that I would just like to highlight for you. First, it provides the typical grounds for resident discharge or transfer. AARP believes that these definitions should be better defined and that their intended definitions could be more precisely specified in the implementation regulations. Also, it outlines the discharge process, including what the notice and the documentation from physicians that certain discharge criteria have and how it should be met. It also outlines the requirements and timelines for notice of transfers or discharge. It also requires preparation of the resident and a discharge plan. We think that this is very, very important. AARP urges this requirement also be made to require a written discharge plan, with evidence that no harm will come to the resident. Also, it requires that the involuntary discharge notices be simultaneously sent to the resident representative and to the long-term care ombudsman. We understand that this worthy goal of protecting the rights of our older citizens and citizens in these facilities did not move forward in the past two legislative sessions, but we do sincerely ask that you move it forward this time. AARP advocates for matters critically important to people aged 50 plus and families, including prioritizing caregiving and the quality of life and the quality of care that our Kansas citizens here in Kansas absolutely receive. So for all of those reasons, AARP Kansas asks that you do support HB 2246. Thank you.
Thank you. Next, I have Alexandra English.
Thank you. Thank you to the committee. My name is Alexandra English. I'm the managing attorney of the Kansas City office of Kansas Legal Services. I've been practicing at Kansas Legal Services my entire career, the last 14 years, and I've been assisting seniors in the state of Kansas for the last 14 years. I was appointed by Governor Kelly in 2020 to the Board of Adult Care Home Administrators, and I'm the statewide director of our Kansas Legal Services Elder Rights Project. I was also on the committee for created the subdrafting or the committee to, the committee that was created for the Judicial Council for this House bill. And we had a particular objective. The objective was to create an appeal process for involuntary discharge of residents from assisted living, residential health care, and home plus facilities. And what if we did, what would the procedures be for that process? We weren't asked to say, yes, we should enact this, or no, we shouldn't. This committee was comprised of members that are both proponents and opponents of the bill. We were provided with research about other states' laws. We were able to see what other states did for assisted living facility residents in this situation. Most states do provide for an appeals process for assisted living residents. Kansas is one of the few that does not. So at the end of the day, the majority of the committee determined that it wasn't House Bill 2246 at the time, but that the language that we created for this bill was the best, most comprehensive plan that balanced the rights of residents to appeal involuntary discharges while also giving assisted living facilities the ability to keep residents safe and preserve their business interests. At this point, I'd like to take off my committee member hat and put on my advocate and my attorney hat. Like I said, Kansas is one of the few states that does not allow a right to appeal. Nursing home residents have the right to appeal through the Office of Administrative Hearings. Tenants in the state of Kansas who live in an apartment, they can appeal their cases through the Kansas Landlord Tenant Act and through the courts. Homeowners who are facing foreclosures, they have the ability to go to court and fight for their homes. This is a situation of assisted living residents who they have already lost the home that they lived in when they were in the prime of their lives. They have moved on to assisted living. They may be experiencing memory problems. They feel like they're losing their dignity. And when they get kicked out of a facility like this, they have zero legal recourse. And it's not fair. They deserve to have a voice too. So I urge you to pass House Bill 2246. Thank you.
Thank you. Mike Burgess.
Thank you, Mr. Chair and members of the committee. I'm Mike Burgess, the Director of Policy and Outreach at the Disability Rights Center of Kansas. And I'm going to do my best to give you a couple of extra minutes back because the previous conferees have done such a great job of explaining the benefits. I too want to applaud the efforts of at Representative Kincannon's request of convening an ad hoc committee to make recommendations. I do think that those recommendations strengthen the bill. We supported previous versions and are back to share our support for this version as well, and appreciate everyone that's worked to get us to this point. With that, Mr. Chair, I will be happy to stand for questions at the appropriate time.
It's impressive. Mike can usually not introduce himself in less than a minute. Committee, we have written proponent testimony from the Kansas Trial Lawyers Association. Any other proponents here today? Okay, questions for proponents. Representative Smith.
Thank you, Mr. Chair. I think my question is going to be for Miss English. While you're coming up, I think of a situation where an individual was had a condition that they had to be transferred to the hospital temporarily, but while they were there, they were discharged. They were given notice while they were at the hospital, etc., and told there just isn't a bed. What do you propose that this legislation would allow you to do to penalize those who would do that, or to remedy the situation? I don't see this stopping them if they're willing to go to that length.
Well, I've had a case in a nursing facility like this before, and the benefit of having a process in place for the appeal was that it gave my client leverage to be able to then negotiate with the nursing facility. So while it doesn't penalize, it certainly gives the resident rights and leverage in negotiating for the future and to be able to return. My client had to stay in the hospital for about 4 months because it was not allowed to return. So I understand that this is a very serious concern.
Thank you. Any additional questions, Representative Lewis?
If you could stay up, please. Thank you, Mr. Chairman. So just to follow up on Representative Smith's question. So is the remedy reinstatement, and is that, do you get that by order of the appellate tribunal, or?
So this would go to the Office of Administrative Hearings, and if the appeal were successful, then yes, that could mean reinstatement.
Representative Carmichael.
Thank you. I think Ms. Russell might be the best person to help me with what I'm inquiring about. I can certainly envision the circumstance, and I presume that the opponents are going to testify about this, where an assisted care resident has a change of physical condition status, mental status, etc., and truly they can't provide the care. They can't handle a cardiac patient. They don't have cardiac monitoring, or I can think of 1,000 other examples. What, if anything, happens during that 30-day period? Do they have to keep somebody there that is actually endangered by this, or to somebody there who has now developed sudden onset of behavioral problems that endanger staff and other patients? By the way, I'm in favor of this legislation, don't get me wrong, but I just want to kind of hear from your perspective, how do we deal with a dramatic change in condition? How's this statute proposed
Well,
bills?
there might be two different ways. I always tell everybody it depends because the details matter, right? So that there is a provision for the emergency discharge, and it requires doctors to sign off on the information, just like it does for the 30-day. So that really, those decisions are being made by professionals. And what we are seeing in our office is that, well, they're supposed to be being made by those professionals. And what we see in our office is the notices are given, and that rationale and that evidence is not there. So proper notices filled out properly with the proper evidence behind them would be an involuntary discharge in and of itself is not wrong. It's whether or not it was properly done through all of the steps. So it may be an emergency, or it may be a 30-day situation, or it may be that they have asserted that they would provide care. In Kansas, we do allow these facilities to accept and to make agreements with people for the care that they will provide. And so we also have the ones where they sign an agreement that they would say that they would do this, and they change their mind when they get someone that will pay more money sometimes, or they get more paid for. So it depends. There's so many, but the provision is that with a doctor's proper rationale, the notice for emergency discharge may be appropriate. So they're not there anymore.
The quick follow-up, though, is oftentimes the medical director for this facility is, in essence, the mid-level provider who works there most of the time and is often, from my viewpoint, co-opted, if you will, by the facility management. Is there any appeal when there's an emergency discharge signed off on, and how does that get processed in time so that we don't have a patient who's displaced and then has the bad consequences from being thrown out in the street?
Well, I hate to say this, but once they're discharged, they're going to probably have suffered from that transfer trauma. And a couple things, if it is found later to be during that appeal, if it's found later to be that was improper, then people may have legal recourse for the damages that would have occurred. If it is found, also something that hasn't been discussed here today is that there are regulations around this. And so if they are determined to be out of compliance in how they have issued this discharge notice, perhaps we should be lobbying for there to be those regulatory abilities to cite people and even fine people in those ways.
So we're not giving these facilities immunity from wrongful discharge actions in this bill. Answer is we're not. Thanks.
Representative Kincannon.
Mr. Chair, Representative Carmichael and I are on the same page today, and he just asked my questions.
Representative Schreiber.
And I'm not sure who would like to answer this, but my question is on page 7, dealing with the definition of an emergency situation. So do the nursing care facilities already define what an emergency is through Secretary for KDADS? And if so, why wouldn't that then be applied to assisted care living facilities? Am I making myself completely unclear?
Well, in generally, what we deal with a lot, because it is more clear guidance, are federal. And so generally, what was intended in rare and specific instances, and I can give you a couple, like obviously acute care situations where people have to go ahead and go to a hospital, or where someone willingly and intentionally, these are just adult care homes are just a broader part of our society. So someone actually may commit a crime whereby they would have to be removed from those premises, and that would be an emergency situation that would be appropriate to go through that process. So those are just examples. I would say that actually brings me to that one thing that we brought up about providing clarity in section 2C7 about on the location for transfer. I don't know why we have unknown in there exactly, other than for those emergency situations where someone might be transferred, quite frankly, by a sheriff's office to where I don't know. Because other than that, location should be specific and a known location. The 30 days is to for the discharge planning, and you have to know where you're going to appropriately do that. So thank you for that question too.
Any other questions for the proponents? Representative Osman.
Thank you, Mr. Chairman. I've got a question for Ms. English.
Yes.
Thank you for your testimony. You had mentioned that you wear multiple hats, and one of them is the Kansas Legal Services, where you're fully in support of this piece of legislation. But the other part, the other hat, comes from the Judicial Council, which, as I understand it, investigated this and has and made the recommendation to bring it forward for our consideration today. Can you explain why they might be neutral on this piece of testimony? I know you're not here representing them, but they're and it's just written testimony. But are you able to comment as to why one hat is positive and one hat is neutral?
I don't know the answer to that. No. I haven't read their written testimony at this point in time, so I'm not sure. Sorry.
Generally, unless the Judicial Council introduces legislation, it takes a neutral standpoint. So that's, I'm guessing why. We can inquire of that later. But Representative Humphreys.
Thank you, Mr. Chairman. I think this is a quick question, and I don't know who will answer, but just the difference between the adult residential care facility and a nursing home. But then someone mentioned memory care. And so do most places that advertise they do memory care, do they fall into one of these or the other? And how do they comply? So are they trying to do the adult residential care facility because it's a little bit, right now they don't have to do the notice, or how, if you could explain that just a little bit.
Well, I appreciate the question greatly, because in Kansas, really any of the facilities, nursing home, boarding care, home play, any of them can just say they're a memory care. And it is a common thing. We have people really contact us and really be upset because they're like, but they're a memory care. It's like, it doesn't really mean anything in Kansas.
We don't have a definition.
We don't. We have it. So we have regulation, and really what it says is that they put themselves out that they will, and that they will provide training to their staff. There's no standard, there's no criteria for how much training or what that training is.
All right, thank you.
Thank you.
Any other questions for the proponents? Okay, committee, I show written neutral testimony from the Department of Aging and Disability Services and the Kansas Judicial Council. Anyone else say neutral? If not, we will move on to opponents. Mark Schulte is who I have first. Unless anyone would like to go first.
Good afternoon, Representative Patton and committee. I have submitted written testimony, but I just like to really kind of focus on one part of it, kind of based on what we've heard today. I'd like to focus on in 2013. My name is Mark Schulte. I'm a board member of the Kansas Adult Care Executives, a nursing home administrator for almost 20 years. I'm currently at Via Christi Village at McLean in Wichita, which is a CCRC. We provide long-term care, assisted living, and independent living. So we have multi-levels of care. I'd really like to focus on one part of what I included in my written testimony. In 2013, Public Broadcasting System aired a program on its Frontline program about a assisted living provider, which at that time was the largest one of the largest assisted living providers in United States. In this expose, they documented more than 24 residents who should not have been in assisted living. Their care had surpassed the care that's provided in assisted living. Every one of these residents that were there died because they didn't have the proper care. In this instance, it was because there was pressure on each of the individual communities to keep them there for a profit motive. We don't want people to leave from an assisted living. We don't want empty beds. We want our beds to be full, but we want to be able to provide care. Assisted living and long-term care are two very different kinds of care. There are two very different kinds of acuity that's going to exist in those. When we do a discharge, I've done 3 since January 1st, but they were with the family. We took all the steps to get to that point, talk with the family. Here's why we're no longer appropriate. We always try to work with those, with the families. We need to make sure we do that. For those people that have not had experience, that's unfortunate. It should never happen that way. A 30-day notice, involuntary notice, is really a standard. That may not be in regulation, but it's a standard that is practiced almost universally. I've only done 5 of those in my career, and in each case, the residents were not appropriate for assisted living, and the family's objection was cost, not the care. This bill will put into practice what happened in this 2013 documentary as a practice. Keep them there longer when their care is going to be compromised. Nobody wants that. The most important thing on my resume is that my first community that I worked at I was Benny Schulte's son. My father was a resident there. I practice my license, make every decision as if it affects the life of somebody I love, because I had the opportunity to do that. We have to do that, and we have to continue doing that. 23 years ago, I was diagnosed with Crohn's disease, and I needed a invasive surgery. I didn't have that done in a minor emergency care center. I had that done in a hospital by people that were qualified to do the surgery. We can't serve assisted living residents. We can't serve long-term care residents in an assisted living setting. Thank you.
Thank you. Linda Mowbray.
Thank you, Mr. Chair. I'm Linda Mowbray. I'm President CEO of the Kansas Healthcare Association and the Kansas Center for Assisted Living. We are a trade association, and we do represent all levels of care in these adult care homes in Kansas. Let me tell you why KHCA KCAL is opposed to this piece of legislation. It's not because we don't think people should have the right to be heard and to have their needs addressed. Open communication is a foundation, a benchmark of a good facility. But in Kansas, our regulations are written so that, we've talked about skilled nursing. A nursing home has nurses round the clock, 24 hours a day. An apartment, you sign a lease. You're renting an apartment, not care. When you come into an assisted living in Kansas, we're a blend. We consider it housing with services. So yes, you are contracting for your apartment, but you're negotiating with the provider for services. For example, an individual may need help bathing, grooming, doing their laundry, and the facility says, okay, we can do those things, and we're going to charge X amount of dollars for each one of these services. And perhaps you say, you know what? I really think I could do the laundry. So on our negotiated service agreement, we say, family will do laundry. They're the ones responsible for it. Facility's not. And we're not going to charge for that service. So what happens when the daughter moves out of town and she can't do the laundry anymore? That's not a change in level of care for the individual. That's a change in service needs. So we go back and we renegotiate and we say, okay, we'll do the laundry and this is what it's going to cost. That's an easy fix. But what happens when it's insulin? What happens when it's a care need and the resident and their circumstances changes? If we don't have nurses at the ready when that person might need the insulin, there's no negotiation we can do. We don't provide that service. That's not part of our portfolio. Now, if the resident can find someone that's capable and competent, or if the family can find someone capable and competent, that's fine. But if you're expecting us to do a service that we can't do, then that's when it's time for that 30-day discharge. And the appeal process, who's going to take care of that resident and give them their insulin during that 30 days or longer because of an appeals process? Who's going to pay for that care? And who's going to be liable when that resident is at risk and has a bad outcome? I'll stand for questions at the appropriate time.
Thank you. Shelley Gromer? Oh, Shelley's online. Okay.
Good afternoon,
There we
Mr.
go.
Chairman and committee members. Can you hear me?
We can, yes.
Okay. My name is Shelley Gromer. I'm the VP of Operations for Guest Home Estates. We're a very small company that has 6 assisted living facilities in Southeast Kansas. Our facilities are in Caney, 2 in Chanute, 1 in Erie, Pittsburgh, and Garnett. Our largest facility has 25 rooms, and our smallest has 11 rooms. I'm here today to present opposing testimony, House Bill 2246, concerning the Adult Care Home Act, relating to the involuntary discharge and transfer of residents from adult residential care. Our facility does do a 30-day notice, and we are responsible in that 30-day notice. The extra burden for us, if this gets passed, is the financial burden. This would cause our facility to hire extra staff. I have provided some data on our facilities. Out of the 6 homes, we total 99 residents at this time. And as you can see, I've listed out on the sheet what our percentage of our Medicaid is. So you can see that our facilities are predominantly Medicaid. If you average it, we're 64% Medicaid in all of our facilities. And if you look at it, we have 74 staffs in our six buildings, with one of our buildings having to have agency at this time. So if you take that and you look at our average Medicaid portion, which I looked at, we average $2,170.67 per month on one of our on one of our homes for a Medicaid resident. The average pay of a CNA is $14. So if this bill goes into effect and we have to wait 30 days to have someone sit with this person, let's say they were an elopement and we have to wait for the appeal process. We're not going to allow this person just to be on their own. We are going to have to put one-on-one staff with them. So if that is the case, then per day, a CNA would cost us $112 for an 8-hour shift. For a full shift for 3 CNAs only will cost us $336 for just one resident. So for 45 days to wait for the appeal, it'll cost us $15,120 to care for one resident. That's for a CNA. The average pay for a CMA is $18. So that would be 432 days, and for 45 days would come out to $19,444. And that's if we're able to find the staff. As you can see, for all the buildings, we don't have an extended amount of staff. So if we were to hire agency, you're looking at $36 to $54 an hour for agency staff. So if you look at our Medicaid average, that doesn't even cover a quarter of the cost it would take to provide care for one resident for 45 days. Our private rate is $3,500 or $115 a day, and that would barely cover one of the CNA shifts. Passing this bill would mean that 3 private pay residents would be covering one person's staff. At this time, I've only pointed out the financial side of it. The other side is the emotional side concerning our staff and our residents. Part of any facility's responsibility is deem who is appropriate for our facilities. With this bill, this responsibility will be removed from that without considering the amount of staff, the amount of care we have in the building, what is going on with that resident. And yet our facility would continue to be responsible to give the best care that we know how to do. In conclusion, please consider what I have reported and do not support the House Bill 2246. This bill could put our small homes out of business and cause problems for our staffs and our residents. Thank you.
Thank you. Lori Owen.
Good afternoon, Chairman and Committee. I am Lori Owen. I am Compliance Director for Sunflower Care Homes. We are Home Plus in Emporia. We have 2 locations there and 2 in Baldwin City as well. Generally speaking, Home Pluses haven't really had a whole lot of information put out there on how we function. So I'm here to speak to you on how our day-to-day runs and how it could be affected if appeal was placed on our facility. I run 2 staff at all times, 3 shifts a day. So it's more of a home-like environment. Our homes are mandated to 12 residents or less. So we have a 6-to-1 at most staffing ratio, which is immensely better than some skilled facilities. And we are proud of that fact. And in my 2 years' time, I have not had to involuntary discharge anybody, but the thought of having to do it and the amount of taxing effort it would put on my staff if we had somebody we could not provide care for and have to bring somebody in. I will say the current staffing market that we're fighting with, I myself have had to work shifts just to make it through and take care of our residents. So I can see the burden that it would place on that. It saddens me to hear the bad experiences people have had. So I just don't want to see it turn into punishing those of us that follow the rules. So I stand for questions.
Thank you. Rachel Monger.
Thank you, Mr. Chair. I am Rachel Monger with Leading Age Kansas. We are the nonprofit faith-based association for senior care. We have about 160 member organizations across the state who provide all levels of care, including, of course, assisted living and those residential care settings. First, want to make it clear that none of our objections to this bill are meant to discount any of the concerns you've heard today. There are issues around assisted living and every other type of healthcare that always need to be discussed and worked on, but we believe this bill cannot be the solution to that. I did submit 5 pages of written testimony to you, and it's very dense, and I wouldn't go through all of it even if we did have time. But I know that some of you may be new to senior care world, which is incredibly complex. So I just want to make sure I put some more definitions and more context for you in that testimony. As you've heard many times with the opponent testimonies, assisted livings are not nursing homes. Kansas laws and regulations are written to make sure they aren't used as nursing homes. And our overall objections to the bill revolve around the consequences of forcing an assisted living to retain a resident for whom they cannot properly care. And as you see in my written testimony, we talk about the dangers to the resident, to staff, and possibly other residents, the increased costs for all assisted living residents, less flexibility and much more selective criteria for those seeking assisted living if we had a bill like this pass, and of course, a much higher risk of lawsuits. We have also outlined in our testimony some of the concerns we have regarding the administrative requirements in this bill, such as holding state agencies to what we believe are unrealistic timeframes that they're probably not going to follow, and with no way of enforcing or remedying that situation as well. Also, near the end of the bill on involuntary emergency discharges, how we read the bill is that it does actually require written approval from the Secretary of KDADS prior to an emergency discharge, which we do have a lot of concerns about. So thank you very much for the committee's time today, and we do respectfully request that the committee vote no on House Bill 2246.
Thank you. Committee, you have written opponent testimony from Bethany Village. Also listed on the agenda is Dustin Baker. He's actually a proponent, not opponent. Any other opponents? Okay, seeing none. Questions? Oh, I'm sorry. You're even my list. Representative Heiberger. Lost in my notes.
Thank you, Mr. Chair. Well, I've been lost in worse places.
I have a question from Ms. Gromer, please, on WebEx. Ms. Gromer, thank you for being here today. I just have a question. How often do you involuntarily discharge people from your facilities?
Not very often. It's very, we don't do a lot of it, but when we have, we go through the proper procedure.
Other questions, committee? Seeing none, I'll close the hearing on House Bill 2246. Thank you, everyone, for coming today. Committee, we're going to work some bills. Let's start with House Bill 2127. Thank you, Jesse. We'll have Natalie remind us what this bill is all about.
Thank you, Mr. Chairman. House Bill 2127 adjusts the time requirements that are linked to notice by publication and mailing throughout the Kansas Probate Code.
Any questions for Natalie? Any amendments? Is there a motion concerning House Bill 2127? Representative Heiberger.
Mr. Chair, I like this bill, so I move that House recommend HB 2127 favorably for passage.
There's a second. Representative Schreiber, discussion. Seeing none. Representative Heiberger, you can close.
I should say my office assistant really likes this bill, but my office assistant is me, so I move my motion.
For the motion, all in favor say aye. Aye. All opposed say no. Motion carries. Affirmative votes being recorded. Representative Heiberger and Carmichael. Let's look at 2130. Back to Natalie.
Thank you, Mr. Chairman. House Bill 2130 increases certain dollar amounts in the Kansas Probate Code.
Any questions, committee? Any amendments? Seeing none, is there a motion concerning 2130? Representative Humphreys. You know Representative Hoheisel watches these meetings and laughs at us now that he's not here to make motions. He tells me every day. Representative Humphreys.
Yes, Mr. Chair, I recommend that the committee passes out House Bill 2130 favorably for passage.
Is there a second? Representative Heiberger. Oh, next up, Borjan. Okay, discussion. Seeing none, Representative Humphreys, you may close.
I close.
For the motion, all in favor say aye. All opposed say no. Motion carries. Heiberger, Carmichael, voting yes. House Bill 2131. Natalie.
House Bill 2131 provides a new mission statement for the Judicial Council, which would be to study the administration of justice in Kansas and make recommendations for the improvements therefore.
Any questions for Natalie? Any amendments? Is there a motion? Representative Neely.
I move that we pass HB 2131 favorable for passage.
Is there a second? Representative Titus. Discussion. You're getting better, guys. Okay, Representative Neely, you can close.
I close.
Heard the motion. All in favor say aye. All opposed say no. Motion carries. Heiberger, Carmichael, voting yes. 2144. As brief as possible, Natalie.
Okay. Thank you, Mr. Chairman. House Bill 2144, eliminate rule against perpetuities for trusts.
Questions for Natalie? Are there any amendments? Is there a motion? Representative Owens.
Mr. Chairman, I move that we pass HB 2144 favorably for passage.
Is there a second? Representative Borjan. Yeah, he was fast. Discussion. Representative Carmichael.
Thank you, Mr. Chairman. I think during the course of the hearing on this bill, I may have expressed some concerns about whether or not it was necessary and what the effects were, and perhaps I even suggested some alternative methods of dealing with the perceived problem. I want the members to know that for the most part, I was trying to assist the fine governmental affairs representatives from the Kansas Bankers Association in keeping their jobs. And I appreciate their reception last evening. Thank you. That's another way of saying I was just kind of messing with you.
Any further discussion? Okay, Representative Owens, you can close.
I close in perpetuity.
You've heard the motion. All in favor say aye. All opposed say no. Motion carries. Heiberger, Carmichael voting yes. House Bill 2172. Natalie?
Thank you, Mr. Chairman. House Bill 2172 enacts the Uniform Trust Decanting Act.
Any questions for Natalie? Are there any amendments? Anyone know what this bill is about? No, good. Is there a motion concerning 2172? Representative Curtis. We're spreading it around.
Thank you, Mr. Chairman. I recommend that the committee pass HB 2172 favorably.
Is there a second? Representative Humphreys, discussion? Seeing none. Representative Curtis, you can close.
I close. Thank you.
For the motion, all in favor say aye. All opposed say no. Motion carries. Heiberger, Carmichael voting yes. House Bill 2029. Natalie?
Mr. Chairman, House Bill 2029 increases the time of an initial restraining order and the possible extensions under that order in both the Protection from Abuse Act and the Protection from Stalking, Sexual Assault, and Human Trafficking Acts.
Thank you, Natalie. Any questions, committee of Natalie? Are there amendments? Representative Humphreys.
Yes, thank you, Mr. Chairman. I do have an amendment. It's simple. It just, what the bill says is not less than 2 years and not more than 5. And we're just changing it to say something like not less than 1 year and more, between 1 and 5 years. It's taking that 2 years back to 1 is the reason for that. And do I explain that now, or? The reason I feel like is because due process, because we heard some really extreme cases and 2 years was appropriate for those, but there's other cases that 1 year would be appropriate. And this gives the judges some discretion.
And that's a motion.
That is, I move my amendment.
Is there a second? Representative Neely? And let's see, the amendment just hit my inbox. Take a second to glance at that, if you'd like. There we go. For those of you with good eyesight, it's now on the screen. Yeah, Representative Vaughn.
Thank you, Mr. Chair. Just wanted, it looks like it does, but just to confirm, I wanted, for the committee's sake, wanted to know if that applies to the initial period and then the request for an extension as well.
It appears as though it does.
Mm-hmm.
Yes. Yes. Good question. Representative Carmichael.
Thank you, Mr. Chairman. I think that this amendment is a good improvement to this bill. I shared Representative Humphrey's concerns, and I'm glad the representative brought this amendment. It may not be necessary in every case, but I think we need to allow a little bit of broader discretion here, and so I appreciate the amendment. I continue to have some reservations about this bill, but for today, I'm going to be voting aye.
Any other discussion on the amendment? Seeing none, Representative Humphreys, you can close.
I close on my amendment.
For the motion, all in favor say aye. All opposed say no. Motion carries. Any further, you want your, on the amendment, do you record your votes on amendments? Yes? Yes? No? Okay, any further amendments? Seeing none, is there a motion on 2029? Representative Vaughn.
Thank you, Mr. Chair. I move that we pass out House Bill 2029 favorably for passage as amended.
Is there a second? Representative Neely, discussion? None. Representative Vaughn, let me close.
I close. Thank you.
For the motion, all in favor say aye. All opposed say no. Motion carries. Carmichael, Heiberger voting yes. That's it. Good work, everybody. Representative Schreiber has a comment.
If anybody is really interested in carrying a particular bill, please let me know. I'll be making assignments over the weekend and surprise you on Monday. Decanting.
We don't know. So we don't know. We find out at 3:30 the day before, just like everybody else.
But I prepare these early, so
yeah. What? Fortunately not. Committee, so you'll notice next week's agenda every day says meeting schedule, agenda to be announced. We will get that out as quickly as the bills. Natalie's working super hard, and most of the bills are now in. We've got a few more we're waiting on. We will be working every day, but hopefully Friday of next week. We've got a lot to hear. So we'll be working some of the stuff we heard this week, and then we have 2 days the following week. We'll see. I don't anticipate hearing any bills those 2 days, but we may need them to get some more stuff out. So we'll see. But pay attention tomorrow afternoon. Probably we'll get that agenda out again as soon as we can. I guess I could give you all a heads up of what I'm thinking and the public who's listening in. But I think on Monday we will have the bids, the bill that deals with bids board compensation, the jailhouse informants bill, and hopefully the Uniform Parentage Act from the Judicial Council. That's what I'm looking at. Natalie's looking back at me, but we'll see. You wait for the agenda. That's the official notification. But I hate waiting as long as we've waited, but there are a lot of bills that revisers are drafting, and we're going to get them up as soon as we can. So thank you all. We're done. Have a good evening. We're adjourned.